And dear guests, I would like to welcome you to the International Protection Panel of the conference. The panel tackles one of the most pressing dilemmas in contemporary migration management, and which is the rapid integration of artificial intelligence and data-driven systems in border management and asylum status determination procedures. While these tools are often championed for their administrative efficiency and their strategic value, they also raise several concerns from a legal point of view. I would like to give the floor to Professor Mavruk, and I would like to kindly remind you that you will have 15 minutes to deliver the presentation. I will be showing you some time signs. Okay. You feel free to keep your own timer as well. Okay, the floor is yours.
All right.
Thank you.
Good morning, colleagues and distinguished guests. It's an honor to be here today. My name is Çağla Mavruk, and on behalf of Seçkin Baykal, we are from Nevşehir Hacı Bektaş Veli University. And I'm pleased to present our research titled The Securitization of International Protection. We find ourselves today in a landmark in 2026. If we look at the evolution of refugee protection, we are seeing a profound shift in paradigm. And we began in 1951 with a rights-based protection. We see a profound, again, shift in this because when we look at 1951, we see a right of promise, and also we see a territorial promise, and that safety would be guaranteed upon reaching a state's soil. By the early 2000s, this shifted towards security management, and in favor of security-based exclusion, where human lives are increasingly treated as political pawns in a larger geopolitical game. Let us dive into the legal reality in 2026 right now. On June 12, 2026, the European Union Pact on Migration Asylum will enter into application. And this is not merely a procedural update, it's a fundamental shift toward a security-oriented shared European regime. For national authorities, specifically Immigration and Naturalization Service of the Netherlands, this has triggered a total overhaul of operational methods. In the Dutch context, for example, specifically at Ter Apel, which has one of the biggest refugee camps, reception and preparation process now focuses on extreme efficiency. So they are minimizing handovers and maximizing automatizations. While this speeds up the process, it risks reducing the asylum seeker to a mere data point in the Eurodac, so which now collects biometrics from children as young as 6. However, the core of this system is what we call is the fiction of non-entry. Under the new screening regulation, an individual physically on European Union soil, he's legally there, but actually he's not considered have entered the territory until they pass through mandatory health, security, and identity checks. So this allows for fast-tracked border procedures and returns, essentially creating a legal buffer zone where standard procedural rights are compressed to prevent abuses. Here we see an image of chessboard. The image of a chessboard represents our first key concept, which we mean instrumentalization. This is the most controversial pillar of the new legal framework. According to the Crisis and Force Majeure regulation, which becomes in reality in 2026, we are witnessing a fundamental shift in how crises are defined and managed. But let us call it what it is. As the legal literature suggests, this is the securitization of the individual. In 2026, we are not just seeing a policy change, we are seeing a language change here. By labeling migration flows as hybrid threats, the EU has shifted the narrative from humanitarian need to national defense. When a member state triggers the state of exception based on the 2024 European Parliament data, and technical data actually, here we see registration extends to 4 weeks, border procedures apply to 100% all applicants, and also returns are delayed by an additional 6 weeks. So the danger here, as we emphasize in our paper too, dehumanization of the asylum seeker. When you frame a vulnerable person as a weapon, here, especially in a hybrid war, you effectively strip them of their identity as a refugee. Their protection needs are no longer assessed. They are simply managed as an incoming threat, and also this is where security bargaining replaces the rule of law. Now let us turn to the physical manifestation of this shift, which is externalization. We have analyzed United Kingdom, Rwanda, and also deal, and also the Italy-Albania protocol. These policies are not just administrative decisions, but also they are jurisdictional shell game. Here, states are attempting to fragment their jurisdictional responsibilities by offloading asylum processes to third-party countries. Here, states think that if the applicant is on their soil, their courts have no say, but why is this legally so toxic? We find 3 reasons. 1, rights erosion in transit. 2nd, the safe country mirage. 3rd, shifting the burden. Especially this shifting the burden, moving people to Albania or Rwanda is not solving the crisis. Actually, it's dumping the responsibility on other countries. These models create a protection gap, and where a person is physically under the power of a European state but legally abandoned by its protections. But there are good news, because here ECHR and EGJ step in, and throughout 2024 and 2025, the European Court of Human Rights and Court of Justice have become the final gatekeepers. They are not just interpreting the law here, they are actively resisting legal fictions with concrete rulings. So this brings us to our core finding, the judicial defense of non-refoulement. If you look at the jurisprudence leading into 2026, the courts have laid down 3 non-negotiable pillars. The first one is safety is not a political label. Second one is the shadow principle, and the third one is individual rights versus mass crisis. Again, when we look at the image here, the non-refoulement image, we see the very heart of international refugee law, the principle of non-refoulement. And here, we navigate through the complexities of 2026, the instrumentalization of humans and the automated screenings and the legal black holes of externalization. We must ask ourselves, is this shield still absolute? In an era of security-based exclusion, this principle is no longer just a legal rule, it has become the ultimate threshold for human rights. But we have a problem here, because sometimes we see chain refoulement. What we mean by that, it's no longer just about country A sending someone back to danger. In 2026, country A sent someone to country B, like Albania or Rwanda, and then this country B may send someone to country C and eventually back to the persecution, the place that they fled. What we see here is a domino effect, and we call it chain refoulement. This is why the judicial defense we discussed is so vital, and I want to emphasize that non-refoulement is the red line of our civilization. It's important that we need to know that if we don't obey those rules, we are losing the moral foundation of the international protection system. To conclude our study here, while the 2026 Pact and externalization models try to move the border everywhere, the judiciary is reminding us that the law must also exist everywhere. The right to asylum is not a threat to state sovereignty. It is the ultimate measurement of a state's commitment to the rule of law. Thank you for your time and your attention, and I am now happy to take any questions.
Thank you very much. It was very timely, and you finished even 6 minutes earlier than the 15 minutes time allocated. We will be taking the questions at the end. And is there anything you would like to add, or maybe during the question and answer session? Okay. Thank you very much for highlighting the importance and the moral value, not only legal but also moral value of non-refoulement obligation and the impact of securitization and instrumentalization of migration policies. And now we can move to our second speaker, Dr. Gökçe Konyalı from Akdeniz University. She will be presenting us data-driven asylum decision-making and individual risk, the problem of the EU's 20% threshold. In fact, this is an important selection of the topic because we will be moving towards the application in Turkey in the third speaker's presentation. I would like to give the floor to Dr. Konyalı in order to zoom in the specific challenges in EU's new data-driven asylum system. Okay, the floor is yours. Okay. Thank you.
Okay, thank you, Professor Ergin. I would like to thank to the scientific committee and the organizing committee for this important event. Today I'm going to discuss about a highly consequential feature of EU Pact on Migration and Asylum, and basically the 20% threshold issue. So I will go to the subject very quickly. So what is the 20% threshold and why does it matter? So the idea is simple, it's basic. If a third country has an asylum recognition rate from the EU members equal or lower than 20%, then the applicants from this country will be subjected to accelerated procedures. And these procedures are different from different perspectives, different from the regular procedures. So the process is wholly changes when you subject the applicant to an accelerated procedure. This applicant may be a third country national, or if he or she is a stateless person, can be a former habitual residence in a third country. So in EU-wide, we use this 20% threshold, basically a proxy to an unfounded application, unfounded claim. So we don't know, we are just doing this based on numerical data, statistical data, and we subject these applicants to accelerated procedures. So they will subject to different time frames and different rights on this issue. So accelerated examination is the first stage of this examinations. There will be a screening procedures and etc. other examinations, and basically member state authorities assessing the asylum claims in first instance, and in this process, after the end of the screening process, they will either direct this applicant to regular asylum procedure or border asylum procedure. So border asylum procedure is also a kind of accelerated procedure and a different procedure from the regular one, and with the other conditions set, if this applicant carries the conditions on the Asylum Procedure Regulations, Article 42, and has the 20% threshold if the 20% threshold applies to this applicant's country, then it will be mandatory to the member states to direct this applicant to the border asylum procedure. So it can be mandatory at the merits examination if 20% threshold applies to this applicant's country, basically. So there is a problem here, the main question of my presentation, that asylum claims should be assessed considering the individual risk, because the asylum seekers have to gather evidence and gather their story, tell their story that they have a subjective risk in their countries or the countries they will eventually turn back. So they have a risk, they have an individual risk or a threat, or maybe there's a risk of torture, maybe there can be a inhuman treatment, maybe death penalty, we don't know. So this can change from person to person. So the individual risk and subjective situations are key in the asylum examinations. So making an inference from a subjective data like 20% or something like that, you are just making this claims, you are just basing these claims on a objective data which is not compatible with the right to asylum and the basically fundamental rights of the asylum seekers, basically. So when we look at the legal structure, you can see the time frames, the different time frames, time limits of different procedures. The first one is regular standard procedure. The second one is the accelerated examination, and the third one is asylum border procedure. And this shows the time limits of the examination processes and the differences between it. You can see the first one, especially the merits examination, can take 6 months on regular procedure, but on the border procedure, which is the last column of it, it's only 12 weeks, which is basically 3 months. So the lodging the claims and the appeal processes, time frames are also different. This is also basically the same chart showing a little bit detailed about the time frames. So I'm not going to go into further detail about the exact time limits, but you can see the chart here. So it's much more shorter time frames in asylum procedures, and there are much more, the accelerated procedures are shorter than the regular procedures, basically. And this may be disadvantageous for the asylum seekers because they have to actually rebut a presumption about being manifestly unfounded claims, about having manifestly unfounded claims. They have to rebut this presumption under time pressure. So they have to gather all this evidence, all their documents, and they have to tell all their stories into this strict time frame, and they have to rebut this, quasi-presumption of being manifestly unfounded. So this is the burden of proof. In this situation, the burden of proof shifted to the asylum seeker. And also there are some differences between the appeals process. In the border procedures, applicants has not been authorized to enter and reside in the member state territory. They have to reside in designated areas. It's kind of a detention-like center. And there's also other problems, other criticisms in that area. I'm not going to, this is not my presentation's main question, but this is also problematic for the rights for asylum seekers. So these detention-like centers and designated areas around the borders, and they have to stay there. They do not have the authorization to enter and reside in the member state. In the appeals process, if they got rejected, their asylum claim get rejected, in the border procedures, they do not also have authorization to stay in the member state. In the appeals process, there is not an automatic suspensive effect of the decision, so they have to leave the member state if their claims, if their applications got rejected, which is completely different from the regular procedure. In regular procedure, they can still reside in the relevant member state. So this is also problematic because when we look at the European Court of Human Rights decisions, they also states in their various decisions that if there is not an automatic suspensive effect for the return decisions or rejections, so there won't be an effective protection against non-refoulement principle, basically. So this is also not compatible with the European Court of Human Rights decisions, and also it's also a problem for the right to asylum. So why is the 20% presumption is problematic? I generally made three main criticisms about this presumption. So the first one is normative and practical concerns. As I said earlier, this being under a threat or a risk is an individualized threat, is not a country trait you have. You know, the person, the asylum seeker, is the person who is getting the international protection, not the country. So you are just. This is not compatible with the fundamental rights and right to asylum. So EU member states also have guaranteed the right to asylum in EU Charter of Fundamental Rights. They also have some obligations stem from the 1951 Refugee Convention. So they have to abide by these rules. But just assuming a claim is unfounded by a statistical data is, as I said earlier, it changed the burden of proof, and it shifts the burden of proof to the applicant. It's also important that I also would like to mention about a statement from Amnesty International. Amnesty International basically says that if a country has a 20% recognition rate for international protection, so this country is not safe for everyone. It can be 20%, it can be 15%, it can be 10% of people got asylums, got international protection. So this means that this country is not safe for everyone. So 20% is not a low rate for recognition, and they are also emphasizing this issue also. So the second concern is about it's basically procedural. So they have strict time limits. They don't have a right to enter the state country. So of course, there are some safeguards regarding this issue. Member states have to provide free legal assistance and representation, and they also need to abide by some regulations. But these safeguards I don't think they are sufficient, because in real life, these people also are generally vulnerable people. So they are in a country they probably do not their language about, so they also may have trauma. Maybe they're escaping from war. We don't know. We don't know what happened to these people to leave their country. So they may have trauma. They have unstable housing. Maybe they're probably staying in these detention-like centers or border centers. So they have limited access to the outside world and legal representation. So basically, these are the main problems. They also, I would like to also address the limited access to the recourse, because sometimes these applicants may not have the access to their own records. So this is also a problem. Sorry. And the third one is, what is the 20% means? Actually, I'm going to speed up a little bit. So the 20% is a EU-wide data. So it involves all member state data, but it can change maybe changing from a member state to member state, because one member state may be much more willing to accept asylum seekers and the other one do not. Of course, there are EU procedures they have to obey, but country practices basically change from each other. So there are some, of course, these are the blind spots. The Eurostat data will be used on these 20% assessment. So we are getting this 20% data from Eurostat, and they will be announced annually. But we don't know, there are actually some problems about this issue because we don't know when we use the newest data. For example, if someone made an application and then it went further to the, it goes further to the appeal process, we don't know which time frame, which data, and which time frame we are going to use for this threshold. So basically, these are the questions. Actually, these are not the theoretical questions. These are also expressed by some member states, and they're also their concerns about this. So I just gathered it into a slide. So how should authorities treat temporary fluctuations? We don't know about that. How frequently should the reference point be released? What is the reference date? How should pending appeals will assessed? So this is basically the main question. Ultimately, I'm not going to say that it's the accelerated procedures are, or the border procedures are totally useless or unjust, because of course there will be people try to abuse the system. There will be bogus asylum claims. Of course, this will be happen, but at the end, we have to look into the fundamental rights, because states, of course, they have to protect their public security, public order, but at the same time, they have to protect fundamental rights. This is a traditional, controversial issue of the international law, basically. You know, sovereignty, it's not only a power, it's also creates obligations under states, so we have to balance this considering the vulnerabilities of the asylum seekers and consider the right to asylum, which explicitly stated in the EU acquis. Thank you for listening. Thank you so much.
Dr. Konyalı, thank you very much for your presentation and very good time management skills. Thank you. We were able to listen to the risks associated with the use of 20% threshold, not only connected to the risk assessment, but also connected to the weakening position in terms of offering procedural safeguards to the asylum applicants. I agree with you, because the states are also required to balance the two sides. On the one hand, there is an increasing backlog of individual applications, but they also need to melt down this accumulated backlog, and accelerated procedure may be a formula to do this without sacrificing the procedural safeguards, obviously. Thank you very much once again. Now we are moving to the third presentation by Ms. Elif Baykal. She is also a Bilkent Law School graduate, currently working for an NGO as a legal consultant. The name of the NGO is Migration and Asylum Research Center, IGAM. Ms. Baykal will be presenting us the effects of digitalization on migration, the use of artificial intelligence in asylum procedures in Turkey. From the EU perspective, we are going now towards a national implementation. And to hear about the national level implementation, we are giving the floor to Ms. Baykal. The floor is yours. You will have 15 minutes. Thank you.
I want to start by expressing my thank yous to Dr. Ayşe Dicle Ergin, and also for the Bilkent University for the organization of this event. And if it's okay, I want to present there because I can see the screen.
Sure, sure.
Okay. So as you know, this topic was already highly relevant, but with the current events in the Middle East, I think it has the potential to become even more relevant now that we are estimating a large level of migration flow. And my topic was about the employment of artificial intelligence technologies into the one of the most critical aspects in asylum governance, the refugee status protection, refugee status determination, and more specifically, what it means for the institutional and legal capacity in Turkey. And this issue matters because the results of the refugee status determination decisions are existential in consequences. It has impacts on the one's right to life and security and liberty. And an error's decision can lead up to refoulement or family separation or denial of international protection. And since with the increasing usage of AI, we see that these technologies are getting more and more employed in public governance, but also in asylum governance. But this raises a question on to what extent can these technologies be legitimately integrated into the decision-making process that determines whether a person should be sent back to persecution. My research will focus on three main domains, the first one being the EU Artificial Intelligence Act, and currently the most comprehensive act on AI systems. It regulates the usage of AI for both the systems themselves and for the deployers. It foresees a risk-based model where it determines the level of risk based on its possible implications for human rights concerns. On the highest level, we have the prohibited risk, where its usage by the governments is strictly prohibited. And examples for this could include risk scoring technologies. Underneath, there's the high-risk systems that have the potential to have implications for severe implications on human rights. And examples of this include the AI systems used in asylum governance. And the implications of that being the governments have to deploy certain legal safeguards, but I will be talking about this later. And below there is the limited risk category where technologies such as ChatGPT or chat boxes are regulated. And down below there is the minimal to no risk category where there's no procedural safeguard needs at hand. I will then move on to the implications of employing such technologies to the fundamental rights of the applicants. And I will mainly focus on the right to privacy and the right to non-discrimination and the right to an effective legal remedy. And then move on to Turkey's readiness on institutional and normative levels for deploying AI in asylum decision-making for such high-risk systems. The architecture that governs the usage of artificial intelligence in asylum decision-making procedure consists of various levels, the fundamental one being the international protection norms, especially the principle of non-refoulement regulated under the Geneva Convention. On the European side, we also have Article 3 of the ECHR, protection from ill treatment, and these together sets the foreground for the obligation for individualized assessment, meaning that the AI technologies deployed in such systems also have to obey by these individualized assessment rule. On the second layer, we have fundamental rights concerns that could arise during these procedures. That includes the right to good administration, privacy and data protection, non-discrimination, and an effective remedy, which means that the AI systems that are going to be deployed in asylum governance should also take these rights as central. And then on the last layer, we have the risk-based AI regulation, which is introduced with the EU AI Act. And under this act, the AI employment by the public authorities in asylum and migration governance is regulated under Annex 3, Article 7C. It states that these technologies should be regarded as high risk, and certain examples of the systems can include AI systems assisting in the examination of asylum applications, the assessment of evidence reliability, associated complaints handling and review, and also polygraphs and emotional state detection tools are also considered as high risk under this act. And being classified as high risk means that the deployers of the systems and system themselves have certain safeguards requirements, including but not limited to implementing a risk management system and having certain data governance obligations, certain human oversight requirements, certain transparency and documentation requirements, and certain fundamental rights impact assessment requirements. If these safeguards are not put in place, it could create risks for fundamental rights. The first one is for the right to privacy and data protection. Since during the refugee status determination, a really sensitive data is used, both for including their applicants' religious background, religious opinion, political opinion, biometric data, trauma narratives, it becomes even more important to properly protect this right. If the deployer of the AI systems does not abide by the data minimization rule, or they don't inform the applicant that they're interacting with the AI, or they share their data without their consent with the third parties, or don't inform that they're taking their data to the applicants, it could cause infringements for the right to privacy. And also, if the AI systems being deployed in this procedures are not trained with data that represents the real-life diversity, or doesn't get educated in a way to interpret cultural or geographical or linguistic backgrounds, it could create biased outcomes that will lead to discrimination. And lastly, if the proper safeguards, including the transparency and documentation requirements, are not met, the reasoning behind AI's decisions will become opaque, and that will create barriers for appeal, which would hinder the right to a legal remedy, an effective legal remedy. There's actually certain examples on the usage of high-risk technologies on both the EU's and Turkey's side. On the EU side, there is currently an implementation done by Germany called Language and Dialect Recognition Technologies. And what this system does is, when an applicant comes for an interview, it takes their voice and compares their voice with the already pre-recorded other voices in the voice data to determine their country of origin. A really similar application exists in Sweden, done by the company Verified AB, which is also used in language analysis and linguistic analysis systems to determine the applicant's country of origin. In Turkey's side, there was a pilot project funded by the EU back in 2019 and 2021, which was called Capacity Building for Effective Nationality Determination. And it was about the development of an AI technology that distinguishes between Uyghur and Uzbek nationals. But the success rate of this project was not really high, so it was not implemented. But it was still important to showing the willingness of the Presidency of Migration Management to experiment with such systems and technologies. The methodological design of this paper will be consisted of a doctrinal legal analysis, where I will analyze certain provisions of the EU AI Act and Turkish asylum framework, and also certain administrative law principles. I will do a literature review, and I will also conduct semi-structured interviews with multiple stakeholders that are working in this field. Some of the interviews that I'm going to conduct are going to be with participants from the Presidency of Migration Management and UNHCR. And I will ask questions to the officials to determine whether, in their view, an AI system could meaningfully conduct or assist in refugee status determination interviews, given that individualized assessment and sensitivity to vulnerability are central for international protection. I will also interview certain academics and legal professionals to get their view on under which respect do they think the draft Artificial Intelligence Act in Turkey falls short compared to the EU AI Act, and can administrative discretionary power be delegated to software systems, in their opinion. I will also conduct interview with the officials from the company Verified AB to learn how the reasoning behind AI-generated assessments are explained, documented, and if necessary, scrutinized by courts, and what are safeguards in place for such systems to better understand the EU's current implementation for such high-risk systems. I will also conduct interviews with individuals under conditional refugee status currently in Turkey to understand whether they perceive the decision-making process as individualized and whether the involvement of digital tools will affect their trust in the outcome. As a preliminary remark, I can say that there are already certain foundational guarantees that exist in Turkey, like the rule of law, equality, right to judicial remedy, individualized assessment under asylum law, personal data protection regime, and the principle of non-refoulement are already codified in the Turkish legal system. But it lacks AI-specific governance mechanisms required for the deployment of high-risk systems, including a comprehensive legislative framework regulating the design, deployment, oversight, and accountability of AI systems, and clarifying the responsibilities of actors involved in their use. This issue is particularly critical in asylum procedures where vulnerable individuals, such as refugees, depend on fair and transparent decision-making for the protection of their fundamental rights. So to the question that I posed earlier, to what extent can the AI systems be legitimately integrated into the decision-making process, I will conclude by saying that responsible and ethical AI in asylum governance is possible, given that certain preconditions are met, including but not limited to establishing a clear legal basis, certain fundamental rights safeguards, designing a system that is transparent. There are also certain institutional requirements that should be made, such as the training of decision makers and implementing certain audit mechanisms and independent oversight. But even though if these preconditions and requirements are set in place, it should not be forgotten that in such a highly sensitive domain, the AI systems in the decision-making process should be used merely as an assistive tool and not as the final decision maker in the process. Thank you for listening to me.